Criminal Law Subcommittee of House Courts will come to order. Clerk, please open the roll. Members indicate your presence. We have a quorum. I'm going to follow the wise practice of the Senate, because obviously they've got it all figured out, and recognize people by how I am told you all came in, since our docket does not have a particular substance order. So I believe that the first person that I've been told is Senator Craig, and you have before us Senate Bill 47.
Yes, ma'am. Thank you, Madam Chairman, members of the committee. I have Senate Bill 47, which is impersonating of a law enforcement officer while committing additional crimes. And I think this bill was last amended back in 2013 when Landis put the bill in, and it was a second offense felony. This puts it as a first offense felony. And, you know, from 13 to 25, things have changed in our world. And after the shootings in Minnesota, that just really solidified that I felt like this bill needed to come back forward again, and it should be a first offense. You know, when the gentleman went to the home of Mr. Hoffman, Senator Hoffman, and his wife, he banged on the door yelling, "Let me in, please, please." And when someone comes to the door and they're in uniform, there's three things could happen. They could be a legitimate police officer. It could be Halloween, dressing up, or a stripogram, or it's someone there dressing up and impersonating a police officer to hurt you. And in this instance, it was. And so he not only killed two people, he shot two others and wounded them. And I think it's time now that we amend our code to state that impersonating a police officer is first offense felony.
Thank you for that explanation. And you referred to a specific incident. Looking at the bill, the question becomes, since you have spelled out the security measures of any business, commercial building, or residence, why wouldn't you also put in government buildings?
It was amended. This was a recommendation from the Senate courts, and I would not have a problem with a friendly amendment of that. If you're impersonating a police officer in any building or any residential, whether it's government, commercial, private, home.
Counsel, is there a recommended way in which you think this needs to be amended to include government and public buildings?
I think it states public already. Business, commercial, residence.
In looking at the bill, Madam Chair, the language specifically says any business, commercial building, or residence. So because I would not think that a government building would be considered one of those three. I think plainly just saying government building would be okay. I'm trying to check the code to see if there's any cross-references or any definitions for something like that.
So at this point, an amendment is in order just to add government buildings, and perhaps before full, if it needs to be rephrased to public or any other type, we'll do that before full. So amendments, motions in order?
I'll move the amendments as proposed by the chair.
Any discussion? All those in favor say aye.
Aye.
Okay. Are there any questions from the panel, from the committee? Is there anyone here who wishes to speak in favor of Senate Bill 47? In favor of?
Good afternoon, Madam Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County. Here speaking on behalf of the Virginia Association of Commonwealth Attorneys, we do support the bill.
Thank you. Is there anyone here who wishes to speak in opposition to Senate Bill 47? Seeing no one. Any further comments from council? Delegate Davis? Second. It's been moved in second. Pardon? It's been moved and seconded that we report Senate Bill 47 as amended. No further discussion. Please open the roll. Members, cast your vote. Senate Bill 47 has been reported unanimously by a vote of 10-0. Thank you, Senator. Senator Salim?
Good afternoon, Madam Chair.
You have before us 23.
That is correct. Madam Chair and the committee, Senate Bill 23 is identical to something that passed back in 2024 and went to the governor's desk. But this bill would prohibit prosecutors in all future cases from offering plea agreements or judges from entering sentencing orders that waive the Fourth Amendment rights of the defendant or the rights to seek expungement of the charges in the future. Well, the defendants theoretically can say no. Prosecutors have leveraged over defendants who often have limited period of time to think or negotiate other terms. In some cases, prosecutors ask defendants to waive the rights for a period longer than the terms of supervised probation, meaning that they're subject to searches without causes years after they have completed every other aspect of their sentencing. There are exemptions made in this bill for sexual offenses against children, as well as specialty docket that we have seen in the rise. However, in these cases, the Fourth Amendment waiver is limited to the terms of the supervised probation, or if there is no probation, to 5 years. Our courts have not been routinely sentencing people to a lifetime of what would be considered an unreasonable search against anyone else. And that's what this bill does. It is essentially trying to ensure that your Fourth Amendment rights are protected, that you're not giving them up forever. And in instances we have seen, especially in Virginia, about 90% of felony convictions, enrichments that do result in guilty plea agreements, and vast majority of the folks that take the plea agreements happen to be black and brown. So with that, if you have any questions, I'm happy to take them.
Thank you. Are there any questions of the patron? Seeing none at this point, before we take testimony at council, do you have anything to bring to our attention on this bill?
The only thing, and I didn't know what the intent was, but sometimes judges won't put a strict period of supervised probation. They'll do indefinite, and that can be lengthened for completion of a specialty docket if the patron wanted to ensure that it was a max of 5 years total for everyone, or if that was specifically left out because it wanted to be allowed for completion of the specialty docket, if that makes sense.
Madam Chair, and that does make sense. So when we made that change, we wanted to make sure, again, going back to, we weren't sure what the judges would do, but we wanted to make sure that the specialty docket was not part of it and that it was excluded as well. So I think you have the same interpretation.
Okay, all right. I just wanted to make sure that if the intent was that the waiver couldn't be for more than 5 years, that sometimes judges just put an indefinite period of probation that could be longer than 5 years in certain circumstances. Yep. Okay, I just wanted to clarify. Thank you.
Thank you.
Senator, are you comfortable with that addition?
Yes.
If it excludes the specialty dockets?
That is correct, yep. I'm okay with that.
If you would prepare an amendment, we'll take it up at the right time. Delegate Williams?
Yeah, just a comment, Madam Chair. I understand what you're trying to do. I also practice defense law, and the biggest gripe that I have with the bill is just it feels like it would take a tool away from me that I could use to help my client possibly negotiate something lower. So I understand what you're trying to accomplish, but on the flip side, it takes something out of my pocket. So that's why I'd be voting no.
Thank you. Seeing no one else wishing to speak, is there anyone here who wishes to, in the audience, in favor of Senate Bill 23? We have one speaker, if you'd limit it to no more than 2 minutes.
Good afternoon, Madam Chair, members of the committee. My name is Ashley Shapiro, and I'm here on behalf of Justice for Virginia. I'm also a practicing public defender and have been for the last 14 years. Your Honor, we do support this bill for a number of reasons. The first being that the incredibly racial disparate impact from these plea waivers that we've seen in Richmond specifically. I FOIA'd the Richmond Police Department to check to see how these were being implemented. 96% of these plea waivers are people of color, 95% black men. So the implication and the application of this is incredibly disparate. I've tried to litigate it. There's not much a judge can do. There's not much a court can do to prevent that practice. So this is by preventing the ability to have plea waivers, that's one way to target it. Additionally, this is one of the only constitutional rights that you can waive prospectively. So generally speaking, you waive your right to trial, you waive your right to something happening right now, you get full consultation with an attorney, you can make that decision. This is an amorphous, at some point in the future, I'm waiving a constitutional right that I don't even necessarily understand yet. In practice, the way we see these actually used, generally speaking, I think there's a perception that the police might have a list that they use. This person has a fourth waiver. Let's go search them. That's not how they're being used. And we've talked to public defenders across the Commonwealth. Generally speaking, these are used almost accidentally, that someone is stopped on the street, their constitutional rights are violated, their Fourth Amendment rights are violated. Later on in the process, at some point, we find there was a Fourth Amendment waiver, and that can't be challenged. So there's no exclusionary rule that applies. There's no deterrent to bad police behavior because it's already been waived a couple years prior to, and also that in some jurisdictions, these waivers last up to 10, 15 years. So well beyond a term of probation, well beyond, there's again, a perception that they're tied to probation. This would not impact if a probation officer implemented a waiver of some kind. So we do ask that the committee support the bill.
Thank you. Did you also wish to speak in favor of? For everybody else in the audience, when I ask if anyone wishes to speak in favor or opposed, if you would all come up at the same time so I have some idea about how much testimony we need to be able to accompany. Again, if you could now keep it to less than 2 minutes.
That's fine. Thank you so much. Good afternoon, committee members. My name is Dr. Candace Lucas, and I advocate on behalf of children of color, specifically children of color that have disabilities. We are in support of this bill, and we're appreciative of this bill. Once again, based on the issue of racial disparities in Virginia, I don't know if any of you know, but we're number 3 in the nation for referring children, Black male children with disabilities, to the school to prison pipeline. We're number 3 in the nation, and that is alarming. Okay, so we're hoping that especially our children with disabilities, our children of color that are, quote unquote, giving pleas below the age of 18 and having to deal with that for the rest of their lives do have this opportunity to be protected. In addition, we're hoping that law enforcement as well as the courts will recognize the impact of how these pleas and how violating the rights of children, because I believe that we do that when we give them a plea and they don't understand it, impacts them going forward, whether it's housing, whether it's jobs, whether it's even financial aid. Those areas of their lives are impacted. So we're in support of the bill, and we're appreciative of it.
Thank you. Is there anyone in the audience who wishes to speak in opposition to Senate Bill 23? Again, if you could all come forward. Seeing only one speaker, you have 2 minutes.
Thank you, Madam Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. My comments were going to be directed much in the same direction that Delegate Williams pointed us. Where we would see this impacting, at least where I practice, oftentimes we get an individual who's charged with petty larceny, and the defense attorney comes to me and says, hey, listen, I'd rather him not have a crime of moral turpitude on his record. Can we agree to make this a trespass? Can we withhold a finding and reduce to trespass or ultimately dismiss? And if my answer is, I'd like to do that, but I want to make sure that this is a one-time thing and it doesn't repeatedly happen. And so if I do this, if I give this grace, will you promise that you won't expunge it so that it won't hide the fact that he's gotten this opportunity? And that is usually a negotiated conversation, and the defense attorney says, yes, if you'll make it a misdemeanor, a crime not of moral turpitude, we won't ask that be expunged. And then I say, sure, and we have the agreement. Other places, there are drug dealers who have sentencing guidelines that start at 18 months, and a defense attorney may come to the prosecutor and say, hey, if we agree to a Fourth Amendment waiver, will you go below the guidelines? And the prosecutor says, I will, if you have that Fourth Amendment waiver, because I want to both be fair to your client, but I also want to do protection for our community. This eliminates a couple tools from our toolbox. It eliminates our ability to provide grace, but on a one-time basis and not have it repeatedly abused, because you can no longer, or you would now be able to expunge that grace. And it provides a disincentive to go below guidelines because you're getting some other level of rehabilitation. For those reasons, we do oppose the bill. We have no problem with keeping it capped at the supervised probation period, but the tools, we would still like to be able to use these tools to help defendants, not necessarily just to hurt them.
Thank you. Seeing no one else wishing to speak, and Delegate Williams.
Yes, I would love to see if the lady for Justice Ford would mind coming up and helping me with a couple things.
Proceed.
Yes.
Oh, thank you. So I'm coming at this from a defense attorney angle, and I'm wondering, are you running up against immovable ultimatums when it comes to plea agreements where there is no negotiating and therefore they're having to sign these pleas or go to jury trials, or is there some negotiation? And is this, you said Richmond, is this Richmond heavy, or is this, have we seen it across the Commonwealth where we're not having as much conversation or negotiation?
I can't speak to the negotiation piece elsewhere. I can only speak to that in Richmond. I wouldn't say it's immovable. Typically, for some cases, it is a non-negotiable. The prosecutor will say this has to be in the plea. You know, it's non-negotiable. It is usually a term of a plea agreement that can be negotiated, typically in direct correlation with jail time. So there would be usually less active jail time if a Fourth Amendment waiver is entered. So it enters into this sort of very difficult, almost coercive decision for a person to make. Well, do I want to go to prison for 2 or 3 years, or do I take a break now in this waiver of amorphous right in the future? So it is typically part of the negotiation, but obviously it's against the specter of prison time. It's a very strong tactic. With regard to how they're used, they are used across the Commonwealth in differing ways. In Richmond, we see it mostly in guns and drug cases. In other jurisdictions, there's different types of charges, different types of cases. So I can't speak to how they're done, but it is certainly part of the negotiation, recognizing that that's not the most free of negotiations given the person's rights that are at stake.
Do you follow up?
Yes, Madam Chair. I think that you're touching on what I am asking about, which is sort of what kind of negotiating power there was if there was sort of a standard practice policy that this is how it's going to be. That's one thing, but if this is being approached case by case, that's another thing. So that's what I was kind of getting at. And then, Madam Chair, I'd love to talk with the patron later, but I think Delegate Davis has some questions.
Thank you. Delegate Davis.
Thank you, Madam Chair. Ma'am, I have sorry. Tell me about the percentages that you were mentioning.
According to a Freedom of Information Act request that I did, it was 96% people of color, 95% black males of people who at that time had active Fourth Amendment waivers. And so are you saying that the other 4% did not have them? No, that's of people who had Fourth Amendment waivers. So the other 4% were not people of color. Okay. So either white males, white females, or I think there were a few undetermined. Okay, so 96% of the persons convicted in these Fourth Amendment waiver were African American. Correct.
Are there any further questions from any of the other members? Seeing none, Counsel, do you have the amendment, please, and would you report it?
Oh, we don't need an amendment. We were just clarifying with the patron, and based on the language that is currently there, that was the patron's intent. So we don't need to amend anything.
So you don't need the 5-year?
No,
Thank you.
Correct, yeah. Yeah, we're.
So seeing no one else wishing to, I'm sorry, Senator, Delegate Williams.
Stanley's in the room too, guys. Yeah, question for the patron. Mm-hmm. I wanted to, so I didn't, this lady touched on children's plea agreements. I was hoping that you could tell me more about that, if there were children getting these same types of plea agreements. Because she's...
Actually, no, I don't have.
Because I was not aware,
I don't have anyone
or
in front
I'm
of
not aware if there are children entering into these sort of, because I'm sitting here arguing this is a contractual right and children can't contract. So is that happening?
I mean, not that I'm aware of, or at least based on what we have, Madam Chair, but the way this is written, this would apply to everyone that goes into a plea agreement.
Yeah.
It would not exclude, children versus adults.
I was mainly curious to know if that's happening right now.
Thank you. Again, seeing no further comments and no amendments.
We'll talk later.
Pardon? Oh, okay. Thank you. Final word as patron.
Madam Chair, I think you heard the testimony. You heard, the intent of this bill, and I think it's important that we not only move this forward, but we look at how the system is disproportionately hurting, especially Black and Brown communities, and this would, provide a path forward. So I hope that you all can move this forward.
Thank you. Second. It's been moved and seconded that we report Senate Bill 23, and this one does not need to be referred to appropriations. Any further discussion? Clerk, please open the roll. Members, cast your vote. Close the roll. Senate Bill 23 reports by a vote of 7-3. We recommend reporting. I need to suspend for just a moment. Council, I need to... It doesn't involve you. Thanks, Senator. The sidebar was on the previous vote on Senator Craig's bill should have been to report as amended and refer to appropriations. I need a motion from someone on the prevailing side that we reconsider.
So, Madam Chair, having voted on the prevailing side, I move that we reconsider the vote on Senate Bill 47.
Second.
All those in favor of reconsideration say aye.
Aye.
Opposed? Now I need a motion to report and refer as amended.
And Madam Chair, I move that we report and refer as amended.
Second.
It's been moved and seconded. We report and refer Senate Bill 47 as amended. Clerk, please open the roll. Members, cast your vote. The clerk's got to catch up with us. All right. Senate Bill 47, we recommend reporting and referring to appropriations with substitute. All reports unanimously. Thank you. Okay, and now back to, I believe we have Senator Diggs is the next person who had entered the room. Senator Diggs, you have Senate Bill 55.
Thank you, Madam Chair. What this bill does is there's already a prohibition of sex offenders being in our local parks. This bill would then extend that same prohibition to those in our state parks. This bill is very similar to your bill, HB 250, although your bill addresses a park authority, and this addresses state parks. So I certainly would be amendable to including state parks into your version of park authorities into my bill.
Thank you, and as you offer that, I think the two of them have separate lives, so I think on this one, while they'll be blended ultimately if the statute is amended with both of them, but thank you.
Whatever the chairman thinks best.
Appreciate that. Are there any questions of the patron? Is there anyone here wishing to speak in favor of Senate Bill 55? Anyone wishing to speak in opposition? And we have no one online, so we operate by motion.
Motion to report.
Was there council question? No. Appropriations. Okay, move the report into appropriations. Any further discussion? Clerk, please open the roll. Members, cast your vote. Senate Bill 55 is reported and referred to appropriations unanimously by a vote of 9-0, and it's not even 1 o'clock on a Friday afternoon. Have a safe drive home.
Thank you, Madam Chair, members.
The next senator, Senator Stanley, I see you have 261 before us.
I do, Madam Chair and members of the committee. Good afternoon to you. Madam Chair, 261 comes out from a very specific incident which made national headlines. Kobe and Caleb were two Labrador pups that were dogs that were owned by a lady whose husband believed that the wife loved these dogs more than him, so he took them out for a walk. He then came back, called the police, and said they had been stolen by Hispanic males, when in fact he had shot them in the head, killing them. He was charged with felony animal cruelty. A judge found him guilty, and it was taken on appeal. A 43-page, on a three-judge panel, a 43-page opinion was released by Judge Athey, where he said that because the statute, as it was written, required some kind of cruelty, suffering, that by shooting them in the head and instantly killing them, that did not rise to the level of cruelty to animals and reverse the conviction. This does not create a new felony. It just expands the definition of the felony that we already have in place to include the malicious killing of an animal, a companion animal, to clear up any problem or issue with this. I will tell you, Madam Chair, that the full panel heard this and locked up 8-8. And so therefore the conviction was actually reinstated because it was a tie. However, what it demonstrated is we had a loophole in our cruelty to animals law which allowed this 43-page opinion to occur in the first place. So this takes care of it by basically saying, in a nutshell, anybody who maliciously kills a companion animal, dog or cat, it's the Class 6 felony that's originally in this law. And that's the bill.
Thank you very much, Senator. My only question is, so the maliciously will be determined in the same way that we have traditionally determined malicious acts against human beings within our criminal code?
Madam Chair, I'd answer you by saying exactly right. That maliciously requires some ill will, some black heart, some malice aforethought, which clearly here he took them out with the intention to kill them, to get back at his wife, and so that under this rewording of the existing law, make sure that that would then be covered, and we would not have a loophole or any question that someone who takes out a companion animal in the way that he did and shoots them in the head, just because they didn't suffer doesn't mean they did not do something maliciously, causing a felony to occur.
Thank you, Senator.
Yes, ma'am.
Delegate Davis.
Thank you, Madam Chair. Just have a comment. As Senator said, this happened in our hometown, and I think it's a good bill, and I thank you for bringing it.
Thank you, Delegate.
Thank you. Are there any further comments? Delegate Cousins.
Thank you, Madam Chair. I do just maybe have a suggestion. So the new language says maliciously kills. Should, just to make it a little broader in terms of covering more circumstances, should that kills be injures, like maliciously injures?
Senator Stanley.
Rather than just kills.
Madam Chair, I'd answer the delegate by saying, it's the maliciously injure, of course, I think that's cruelty to animals as well, and it's covered maybe in the injury part of the existing statute. I'm not at all adverse to something like that. What we were trying to do was address a specific situation that, quite frankly, when that opinion came down, it went through our area and region like wildfire, that suddenly this was something okay and that you could get away with it. And so it also tries to cover, there are times where our law already establishes if there is a dog injuring livestock, that would not be covered by this. That's totally different as well. And if humanely was doing it for a humane reason, wouldn't be covered by this as well. But if you believe it should be expanded to include injury, I think Madam Chair understands how I feel about dogs and cats over the years, so I'm not going to be standing in the way of something like that. I think anybody who maliciously injures a dog should be dealt with seriously. And quite frankly, what we've seen is studies have demonstrated that human beings that injure dogs or cats are usually also more prone to injure human beings and take their lives as well.
If I can interpret,
yes,
Delegate Cousins.
Thank you, Madam Chair. And the reason I suggested that is because it seemed like the case that you were discussing, in that case, the judge seemed to make a distinction between the injury being like sustained, which is, I think, the reason why you included maliciously here. So that's why I think maybe we should consider,
if I can just make sure I'm hearing you
correctly,
correctly, Delegate Cousins, you would have killed or injured? Yeah. So you're not replacing killed with injured, it's killed or injured. Yeah.
And Madam Chair, again, I'm not against that. I would. The only thing it'd have to be consistent with is Section A of the existing code, which says any person who Romanet 2 tortures any animal, willfully inflicts inhumane injury or pain not connected with bona fide scientific or medical experimentation on any animal, or cruelly unnecessarily beats, maims, mutilates, or kills. So that may be covered, but sometimes we find redundancy in the code, and I like it to be clear, not unclear, which it is right now, which we're trying to fix.
Counsel?
So I'm going to take the word approach, and I will let other counsel take the court case approach. The subsection that we're amending specifically deals with killing or an animal dying. So you have to torture, willfully inflict that pain, and as a direct result, the animal dies, or has to be put down by euthanasia, or we're adding a new Romanet that says maliciously kills. Injury would not make sense in this subsection. It is already covered, I think correctly, in subsection A, where it says any person who tortures any animal, willfully inflicts inhumane pain, etc., is guilty of a class 1 misdemeanor, or that statute. This statute also is very ugly, so I'm trying to decipher it very quickly, but that is the difference for what subsection F specifically is for. So you can do what you would like to the statute. It just seems a little improper to add injures to a killing subsection.
Before I turn to the other way of looking at this, may I clarify? So is it appropriate within this section that deals with killing to have kill or attempt to kill, maliciously attempt to kill, so that if the animal in fact hasn't died, the malicious aspect that we are going after would apply to the attempt?
So you could, but the way that our attempt statute is written is that it says that any act that is not completed can be charged as an attempt. I think that's 18226. One of the right numbers. So basically, we write the crimes to say this is what the completed action is. If they are soliciting, if they are conspiring, or if they're attempting, those are just different penalties.
They are automatically incorporated within, and we do not have to restate it.
That is correct.
Thank you. Counsel.
And just to speak just to the statute generally, it is a very confusing statute. It's because if you look at A, it also includes kills an animal. And then there's a subsection about killing an animal, a dog or a cat, for their hide is a misdemeanor. And then this makes maliciously killing a felony. And I'm shocked that the Court of Appeals ruled in the way they did, because I would think you could interpret B to be willfully inflict inhumane injury that results in death. It doesn't even say the word cruelty in that section. So I just think it's an incredibly confusing statute in general. I do know that that case is currently on appeal to the Supreme Court. So I don't want to speak for the Supreme Court, but I'm guessing they will reverse or uphold, I guess the conviction would be my guess, but that would be my guess. But this statute is nuts, I guess, but
Thank you. And having been a little part of some of the history of this, and often it does come from bad cases, there's no question about it. So this is one of the reasons that we have what we have. But I'm also going to say within this, reading all of that history, I don't see the clarity that the senator is looking for as far as malicious killing. I don't see that it's really carried elsewhere. You can talk about one of the reasons that you have hides in there, et cetera, is there's also an agricultural aspect of, as well as experimental aspect of this code. And so it's not as clean as far as focus that we find in the criminal law in other areas. Having said all of that, are there other comments? So at this point, I think we're still with the bill as it has been presented to us. Is there anyone in the audience wishing to speak in favor of Senate Bill 261? Anyone wishing to speak in opposition? Seeing none, we are back then to the committee. And let me also say, I keep on babbling by adding to what I had previously said, agreeing with counsel when I see all of the aspects being covered within one section. Ideally, a bill would be brought forward in the future that would separate this into different sections, just like we see within our general criminal code as far as the circumstances that are involved.
And Madam Chair, just to add to that, I think you and I are both having experience with this. It was 6-8 years ago when we elevated, remember in the Commonwealth of Virginia, cruelty to animals was a misdemeanor. And so the first was the elevation, and then we kept adding some certain things to make more, to bring clarity to it. And so I understand counsel's position, but I think that's something we should do in the future. But in the meantime, someone acts maliciously against a companion animal, killing them, it's not right. It's not human. It's not the right thing. And I think we as the state needs to say where we stand clearly as we can.
Thank you, Senator Knight. I will take that as your final word on the
Yes.
bill before we act. It's been moved and seconded that we report and refer to appropriations. Any further discussion? Clerk, please open the roll. Members, cast your vote. Senate Bill 261 will be reported and referred to appropriations by a vote of 9-0.
Thank you, Madam Chair, members of the
recommendation.
committee, for this thoughtful exercise. I appreciate it.
The next patron who was in the room was Senator Perry. Senator Perry, you have Senate Bill 330.
Good afternoon, Madam Chair, members of the committee. I believe there is a substitute for the bill.
Clerk, Counsel, if you would report the substitute. Do we have it with it before?
Yes, Madam Chair. It's been distributed to the members and it is posted online, or at least it's supposed to be. The substitute is basically identical to the bill that was as introduced. It just clarifies what type of court records we're referring to. If you look, you all should have color copies. Anywhere you see the red word non-confidential, that is all the bill does. It just reinserts that to clarify that we're not giving everyone access to all the records that might be sealed. It is specifically non-confidential records, which is a defined term in this article.
Moved and seconded. Any discussion? All those in favor say aye. Opposed? Okay, the substitute is before us.
Thank you, Madam Chair. Madam Chair, this bill is a bill that I'm bringing. I sit on the Virginia Sentencing Commission along with Delegate Cousins, and this bill is being brought at the request of the Sentencing Commission. Jody Fridley is right here in the room. Virginia Department of Corrections also sits on that Sentencing Commission and requested this as well. But what this really does, this is a red tape cutting bill. Virginia Sentencing Commission is responsible for looking at the sentencing guidelines that are completed every year by judges or throughout every plea agreement. And they analyze the data and they tell us, how many people were sentenced for grand larceny and what were those sentences, and were judges sentencing within the guidelines? Were they sentencing outside the guidelines? This allows them to easily access those records so that they can compute that information. We've heard some concerning things on the Sentencing Commission about their difficulty or inability to get access to the very records. We rely on them to be able to do their job. And so, Madam Chair, members of the committee, this provides their ability to do that more quickly and easily, again, non-confidential information. So information they could get if they wanted to drive around to every courthouse in the entire Commonwealth and pick up all of the sentencing guidelines throughout the year, but that's not a very efficient way to do things this day and age. The other part of the bill deals with the Department of Corrections. Probation officers in the Department of Corrections are the folks who we charge by code with preparing sentencing guidelines. If it's difficult for them to be able to access the information they need, again, contained in the court's file, it makes it difficult for them to, in a timely manner, provide those sentencing guidelines. The code provides that those have to be filed 5 days before sentencing, or else that sentencing may not proceed. For folks who are in jail, if those guidelines are not filed in a timely manner, that may mean that they don't get to be sentenced, and so they continue to wait in jail. So, Madam Chair, members of the committee, this allows them the same access the Sentencing Commission has, any attorney would have, to make sure that we can cut through the red tape and move the process along for those folks and get the information that we need. I'm happy to take questions from the members of the committee.
Thank you. Seeing no questions, were the representatives from the Sentencing Commission and DOC who are here, if you would like to just speak to the bill since this has essentially been brought on your behalf, so that we understand the...
Good afternoon, Madam Chair. Thank you. Simply, all it does is it allows us to use one application to request OCRA access instead of each of us filling out a form. We did that. There was close to 1,500 forms that we'd have to fill out versus 120. And we found this information useful. And as Senator Perry said, it just speeds the process along for us to find the information that we need without bothering the clerks, really. So, well, we appreciate that.
So my basic question was one of the reasons for bringing you forward. Since you've been doing this individually for a dozen years?
A year.
For a year, you have the protocol so that the individuals have the total secure custody of those records, so you don't have any problem of them being shared more broadly, and that having a group of staff that is given access shouldn't produce any problems since you've already had multiple individuals.
Madam Chair, correct. In some courts, they already allow us to do this. They allow us to do one application with all the staff in there. It's the same process. If a staff member leaves, we will immediately remove them from the ability to access the records.
Thank you.
Thank you.
And if you could also identify yourself. Please come forward.
Madam Chair, members of the committee, Eric Barton, Department of Corrections. For the same reasons that Mr. Friedley stated, this would also assist the department and our probation officers with preparing the same reports that the senator spoke of. And so it really just speeds up that process for us. Like Mr. Friedley said, it was different. It varied between jurisdictions, whether we had electronic access or not. So this really just makes it a lot easier for our probation officers to be able to go in and get those records, not manually having to go into the courthouse. So it really speeds that process up for us.
Thank you. Seeing no members wishing to speak, is there anyone else in the audience who would like to speak in favor of Senate Bill 330? Anyone here to speak in opposition? And we have no one online. You have the final word, Senator?
Madam Chair, I don't have anything else to add to the bill. I think it's a relatively straightforward bill that just helps the criminal justice system, the criminal justice process, and make sure that we, as a General Assembly, have access to the records that we rely on to make determinations here. Thank you.
And I assume counsel is no words from counsel. We operate by motion. Report and refer.
Report and refer with substitute.
I don't have that.
Did I?
Is it
No, none for 330.
Okay, move to report.
No, we don't refer. We don't refer. Got it. Okay, so the motion then is to report the substitute. Any further discussion? Clerk, please open the roll. Members, cast your vote. So Senate Bill 330 with substitute, we are recommending reporting by unanimous vote of 9-0. Thank you, Senator.
Thank you, Madam Chair. I hope you all have a wonderful weekend. I do want to say a very special thank you to Mr. Hatcher. He's always wonderful to work with. He was very wonderful on this bill, and so always grateful for him. Thank you all.
Then now we have Senator Favola.
Thank you, Madam Chair. Good afternoon. Good afternoon, committee members. Let's talk about Senate Bill 35 first. Madam Chair, what Senate Bill 35 does is before a delinquent is adjudicated, before there's a final disposition on the adjudication of a delinquent, this bill reminds the judge that he or she may require or may request a mental health analysis or a disability needs assessment. The intent is hopefully the judges will want to gather as much information as possible, and also it would remind them that a diversion and treatment would be a very appropriate sentence to a detention sentence. The bill goes on to give you some timelines. There's also sort of a safety valve in there. If the court, within a 72-hour period, had received a very complete social analysis that actually has the information requested, they don't have to ask for an additional evaluation. And that's the bill. It did pass out of the Senate 40-0, and I hope it is the will of this committee to do that. It reinforces our value of putting our young people into a treatment program, determining what their needs might actually be, and honoring the rehabilitative nature of our juvenile justice code.
Thank you. Are there any questions, comments from the committee? Seeing none, before I turn to the audience this time, I know I don't do this consistently. Counsel, do you have anything to add?
I guess our only question is how is this different than a social history? That was just the questions that Mr. Hatcher and I had. Would this be different than a social history?
This could be different from the social history. Some social histories are quite expansive, and that's why there's an out in here. If, in fact, the information is contained in the social history, then the judge probably would not order this. But some social histories are very narrow and very incomplete.
And would you not agree that it's typical that it's not be interdisciplinary? It could be from one source.
That is true. It usually is not.
Then, is there anyone here in the audience wishing to speak in favor of Senate Bill 35? Anyone here in opposition? We have no one online. Moved and seconded that we report Senate Bill 35 and refer to appropriations. Any further discussion? Please open the roll. Members, cast your vote. Senate Bill 35, we are recommending that it be reported and referred to appropriations unanimously. Vote of 9-0.
Thank you, Madam Chair. And members of the committee, I'd like you to turn your attention now to Senate Bill 198. Now, this bill actually deals with a situation where an individual may have been diagnosed by a psychiatrist or clinical psychologist as being on the autism spectrum, or may have been diagnosed as having an intellectual or developmental disability, as defined in our Virginia Code. In those situations, any statement that such an individual may make to law enforcement prior to a pretrial interview, prior to that, could be deemed inadmissible. So the defendant could be represented by an attorney, hopefully, and the attorney would actually petition the court to not have the statement admitted. And the judge would have to make a determination based on a preponderance of the evidence. The Commonwealth attorney, of course, could counter that and make a case for having the information admitted. That's the bill. I do have paragraph E that explains a little bit more about what the standard should be.
Amendments, right?
Now, getting to paragraph E reminded me, I thank you, counsel, that we do have some two-line amendments to adopt.
I could have the council please report the amendments.
Yes, Madam Chair. I'm going to read them how the paragraph will now read, because they're a little confusing because we're striking entire lines. So it will say, for the purposes of this section, a defendant's decision to speak with law enforcement shall be presumed to have been directly influenced by his disability where, on a properly administered assessment tool, we're going to strike the rest of those lines of 45, and we're getting to practice, comma, approved by the American Association on Intellectual and Developmental Disabilities, comma, the defendant obtains a score at or below the average score obtained by a 14-year-old on the assessment tool's standard measure of adapted functioning in a domain that would impact the defendant's decision to speak with law enforcement.
Is there any questions on the amendments? We operate by motion.
Move the amendment.
All those in favor say aye.
Aye.
Opposed? Okay, the amendments are before us. If before we turn to the rest of the bill, I was informed that now the amendments before us then, you still have on lines 53 and 54 that this needs to be reenacted. My understanding was that with the clarifications that these amendments represent, that the reenactment clause was not necessary any for
Well,
longer.
the reenactment clause came from the Finance Committee, not from the Authorizing Committee. So
would it be a friendly amendment for us to take off the reenactment clause with the idea that it could go into conference if necessary?
absolutely. I would view that as friendly, and I expect you're going to send this to your Appropriations Committee anyways, so they'll
yes.
have another bite at the apple if they want to put the reenactment clause on. So, but it did come from Finance. It did not come from Senate courts.
Well, Madam Chair, I would move to strike the lines referencing the reenactment clause from Senate Bill 198.
Okay. Moved and seconded. Any discussion? All those in favor of deleting lines 53 and 54, the reenactment clause, say aye. Aye. Opposed? Okay. Now, does council have anything else that we need to be aware of? Okay. Now we have several people wishing to speak. If those who are in favor of Senate Bill 198 would please come forward. I see I have two individuals, so if you could speak, if you could share 3 minutes. Thank you.
Thank you for letting me speak. My name is Brian Kelmar, President of Decriminalized Developmental Disabilities. This legislation was put together by a group of experts, prosecutors, defense attorneys, psychologists, law professors. So there was a lot of work to put into this and to resolve these issues. And we support this bill and hope you pass it. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Kerry Citronberg. I'm a practitioner doing criminal defense out of Alexandria. I support this bill. I was part of the working group that my friend referenced just a moment ago. I just wanted to add that I spoke with Nate Green with respect to who's part of the work group, and with respect to what happened in finance. The original financial statement was based on a time when the original bill had the burden on the prosecution. That led to the Commonwealth believing this would create a 36,000-hour requirement burden on them. Since then, we have the bill was changed to have the burden on the defense. I've spoken with Mr. Green, who indicates that number will come down now dramatically when it goes to appropriation, and so I think it is appropriate to take out that reenactment clause and it'll be successful in appropriations. Thank you.
Thank you. Seeing no one else in the audience, is there anyone here wishing to speak in opposition to Senate Bill 198? We do have two people who have signed up online, both speaking for. Teresa Champion from the Virginia Autism Project.
Thank you, Madam Chair, and I'd like to thank the patron for this bill, and thank you to the committee. I'm Teresa Champion with the Virginia Autism Project, and we worked very hard with the group to come to language that would be beneficial. And there are many online comments and support also. As you know, young adults with autism are typically delayed in development, and being able to biologically show that if you're an adolescent, but if you have developmental delays, we worked hard to give the court a way to assess an individual and consider that when they're being interrogated and that is being introduced. So we ask that we support this bill and we ask that you pass it. Thank you so much.
Thank you. And the second speaker is Lucy Bednell from the ARC of Northern Virginia.
Thank you, Madam Chair, and we thank the Senator for bringing this bill. This receives our strongest possible support. For about 20 years, I worked directly with people with developmental disabilities, and we know that that ability to speak and process extemporaneously is very often challenged, especially in high-stress situations. And just a few years ago, we had a fantastic fellow on the spectrum in our office who said, at its core, autism is a communication disability, and my ability to understand and process what is being said and give an answer that is as clear and thought out as I would like it to be is very different than what other people do. And I think this bill speaks to that directly. Again, we give it our strongest possible support.
Thank you. See no one else wishing to speak. Delegate Davis, did you want to be recognized at this time?
Thank you, Madam Clerk. Chair, I'm sorry. Question. How does this help the victims of these crimes?
Well, I would think giving everybody the opportunity to fully understand the situation they're in and to provide accurate information helps the entire justice system. And that's what this bill does. It actually makes an accommodation for individuals who do not fully understand the situation they're in, and their cognitive ability may be at the level of a 14-year-old. So we're, again, trying to enable that the justice system really works in a fair way for everyone.
Any further follow-up, Delegate Cousins?
Thank you, Madam Chair. I just have a quick clarifying question. So it looks like this code section would only apply to individuals who have committed, or it would not apply, so it would accept individuals who have committed violations under 18.2-31 or any act of violence as defined in 19.2-297.1. So I'm just wondering why this wouldn't apply to everyone and why those cases are accepted there.
A determination was made by the work group to carve out the most violent crimes. So that was, maybe we'll come back next year if we see how this works and add those back. But we were trying to just open the door. This is a new section, brand new section of the code. This is a new process. We know attorneys sometimes pause when they see something brand new. So that was the rationale.
Madam Chair.
Yes.
If I may respond to Delegate Cousins' question, that perked our interest as well, so we were looking up some relevant code sections. The deferred disposition statute for persons with autism or intellectual disabilities does also carve out those same
That's true.
Those same offenses. However, the deferred disposition under 19.298.02 does not appear to have any references to crime of violence, and then the introduction of evidence related to a defendant's mental condition under 19.2-271.6, which I would akin this new statute to as it's an evidentiary basic thing. The 19.2-271.6 does not have any exclusions on which crimes it would or wouldn't apply to. That statute is based on defendant's mental state at the time of the offense, and you can introduce that evidence. So we're talking in this instance about the defendant's mental ability at the time a statement was made for law enforcement, whether or not that would be excluded. So those are just differences that we just noticed.
Before recognizing Delegate Williams, I'm going to enter in on this. My understanding, having worked in this area, that in this instance we are talking about the ability to communicate and the ability to understand also what is being said. So on the more serious crimes, you are assuming that that person had the ability to carry out that level of crime as opposed to something where there's a lack of communication and you're being accused of a crime and not being able to bring forward the communication problem, which is, again, far different from a situation of rape and murder and these other violent crimes that are exempted from this. So I'm comfortable that there's a real need for this at the level at which these individuals may be brought into the criminal justice system. Delegate Williams.
Yeah, question for the patron or possibly council if they wanted to weigh in. I'm just curious about how this works with Miranda warnings and then also post council retention or representation.
I'll take a crack at it, but I think general counsel may want to elaborate on my answer. I mean, nothing precludes the Miranda warning, and if the law enforcement officer is following the proper procedure, then the Miranda warning would probably be given. It doesn't mean that the
Madam Chair,
defendant would understand it.
Please.
Right. I don't mean are they going to give the Miranda warning? I mean like after or if or after they give the Miranda warning, like what protections are in place? Did they waive something? I'm wondering after the Miranda warning.
Counsel seems
if you'd like
to want to
respond.
answer.
Yeah, I'm happy to. So first, the statute does specifically say that this would apply prior to the appointment of counsel, so that would deal with the Sixth Amendment right to counsel issue. With regard to the Miranda warnings, obviously, we know they're still required. This would just create a situation where instead of arguing a Miranda issue, or if they didn't understand the waiver, this is arguing a specific... It would be on the defense to show that they suffered from this and that their confession or any incriminating statements were the result of this disability and therefore they'd be excluded. So it's providing like a statutory exclusionary rule, whereas Miranda would still apply. It's just a much harder standard. And then there's kind of a good faith exception if it's not obvious to the officer about whether those statements are excluded. So this is more on the fact that the defendant suffers from this and not about police misconduct. Right. I guess if that makes sense. Right.
That's actually a good answer.
Yeah, can I have a follow-up?
Yes, you may.
So that was my, I wasn't trying to say the officer did anything wrong. It was more what happens at that moment. Can they waive? And she addressed the counsel issue. So going forward, as I'm kind of picking up, I think that should be addressed as best as possible with any kind of legislation that may or may not come of this. I don't know what they're going to do.
Thank you. Seeing no one else wishing to speak, I think it's at the appropriate moment that you have the final word.
Well, Madam Chair, I appreciate the committee's attention to this. It is a new section of the code, but it is an attempt, actually, to ensure that individuals who are interviewed by law enforcement really fully understand the situation, and if they make statements that are perhaps indicative of a lower intelligence or lower cognitive ability, that at least the justice system can address that, can adjust for that. So, and the determination at the end of the day is made by a judge about whether or not the statement can be admitted. So it's your usual give and take process with a defense attorney and a Commonwealth attorney, and evidence will be presented, and we do have some guidelines about what points of reference should be used.
Thank you, Madam Senator. Seeing no one else wishing to speak before I call for the motion, I'm debating, but I'm going to share with this. It's always fascinating for me all my life to figure out how life works. And so as I've lost some hearing ability, it's very interesting to me how my brain works to translate what is being said to me. And I'm not meaning in any way to say that this is part of this bill, but it does allow me to have a better understanding of autism and the brain functioning that is trying to translate what is being said to having meaning within the brain. And we take it for granted, and I certainly have taken it for granted all of my life. So it's very interesting to have a little glimpse into the neurological functioning that, again, many of us take for granted, but this carve-out says there is a role for expert witnesses to determine whether this individual has a history where that degree of understanding needs to be part of the fact pattern. That's right. So having said that, as we operate by motion. Okay. Any further discussion? Clerk, please open the roll. Members, cast your vote. And Senate Bill 198, we recommend reporting and referring with amendments to appropriations.
Thank you, Madam
By a
Chair.
vote of 7-3.
Thank you, members of the committee.
Thank you. I believe that is our entire docket on a Friday afternoon. Thank you all. And we are adjourned.